Good afternoon and a warm welcome to today's edition of Democracy and the Rule of Law, a program where we x-ray topical national issues within the ambit of the law. My name is Judith Renua. Thank you once again for joining us on today's edition of the program. And as usual, our legal practitioners are seated, ready to dissect today's issue. The Supreme Court on Wednesday, February 26, reminded Nigerians that the decision is indeed final. The Apex Court did this when it dismissed applications filed by the All Progressives Congress APC and its governorship candidates in Bayelsa State, David Lyon and Biobarakuma Degi Eremieyo, seeking a review of its judgment in February 13. Hence, on the gubernatorial election in Bayelsa, the Supreme Court's message is clear. That is, it will resist any attempt to belittle its dignity. Therefore, it is case closed and its earlier judgment on Bayelsa is final. Thank you, our legal practitioners, for joining us on today's program. It is nice to have you, Barrister Tunde Kolawole.
Thanks for having me, Judith, and good afternoon to all the people listening to us.
Thank you, Barrister Tokwe Temokun. You're welcome.
Business. I'm good to be here.
It's been a while.
Viewers at home.
Yeah, I'm sure they're happy to see you today. And Barrister Benjamin Ode, you're welcome.
Thank you very much, Judith.
All right. The review of Bayelsa election, when they went to the court, some lawyers were divided over the particular decision, singular decision to immediately go back to the same court, which earlier avoided the candidacy and also the elections and the vote accrued to the All Progressives Congress in Bayelsa State. And now the court has its verdict that there must be an end to litigation. Hence, its decision on that particular election voiding the candidacy of the All Progressives Congress over, the undoing of the running mate of David Lyon stands. It also went ahead to find the senior lawyers who brought this petition back for review to the court. Barrister Benjamin, I'll start with you. Did you see this coming?
Well, as a matter of fact, I expected this would happen because the trend at which the Nigerian judiciary is being ridiculed up to, with these incessant applications for review, was becoming development that is worrisome to some of us who are lawyers. Besides that, yes, the Supreme Court has the authority to make corrections in some instances when the Supreme Court has given a judgment. That is separate, however, from situations where lawyers and litigants are now beginning to make the Supreme Court to also sit as an appeal over its earlier judgment, bringing grounds for the review, stating various grounds for the review. We discovered that this development was beginning to impeach the integrity of the Supreme Court. Now, we have watched the recent development regarding, for example, the Imo State gubernatorial elections and the Bayelsa State gubernatorial elections with concern, great concern. And we have been watching carefully, and now the Supreme Court has made the final judgment at the end of the day. Now, if you look at the totality of that case, if you realize something, that the Supreme Court made it clear and even went further to punish or fine the lawyers who are supposed to be leaders at the bar regarding such application. Yes, it is true that the Supreme Court has the right and the authority to review its judgment, but such review cannot become another appeal. Such review should be reviewed to correct errors that would rather have caused great injustice to litigants. So these are the reasons and the avenues where Supreme Court is allowed or should review. Or yes, of course. However, that situation is also different from a situation where Supreme Court has earlier on set aside its decisions in some cases And that situation is also different. But in this case, what made this particular circumstances, this particular case unique is the fact that it is the same case that the litigants have approached the Supreme Court to set aside its earlier decision. But there we have had situations where the Supreme Court has set aside its earlier judgment in other cases.
All right.
You know, abandoning the former or previous principles that it has earlier canvassed to now say, oh, look, there was a mistake in that earlier judgment.
Okay.
This is the new principle we are propounding.
Very well. Let's look at the prayers of both counsels to David Lyon and the APC, that is Chief Afe Babalola, SEN, and Wole Olanipekun, SEN. Chief Afe Babalola had earlier in his submission stated that the Supreme Court had inherent powers and discretion to set aside its own judgment because the judgment which voided the election of his client was a nullity since his client was denied a fair hearing. According to him, the procedure adopted by the Apex Court on February 13 was wrong because there was no course of action at the time the Supreme Court gave judgment against Lyon. Olanipekun on his part argued that the Apex Court erred in law when it invoked Section 36 of the Electoral Act to disqualify APC's participation in the election when the Federal High Court judgment restored by the Supreme Court did not disqualify the party's eligibility. He also argued that the Apex Court could not give consequential order on a relief not granted by a trial court except due to human error. Barrister Timoko.
Yes. The problem I have with this, the trend in this particular case is that just like maybe 90% or 80% of legal practitioners in Nigeria agree that the conduct of the senior lawyers, to me, is quite reprehensible, in the sense that all of these laws you are talking about, all of these laws of fair hearing, the issue of Section 96, all of these laws we are talking about, the final court that gives interpretation to this court, to these laws, that is binding on the lower court is the Supreme Court. Whatever interpretation they must have given in this instant case, if you now go back to them and you are now questioning those interpretations, what it means is that you are appealing the judgment of the Supreme Court in the Supreme Court. And that is wrong. It is wrong in the sense that the present trend in our practice, to the extent that people believe once you have a case and you have another Anibekun on the other side, or Afe Babalola on the other side, that judgment is secured for you, that trend should be discouraged. And that is why I'm particularly happy about the expressions of the judge who read, the justice who read the lead judgment, saying that I am in tears, that in my lifetime this kind of situation could happen. Afe Babalola has returned to his university in Ekiti. With due respect, he has paid his dues in this profession. For him to have been brought back to come and appear before the Supreme Court to canvass issue of fair hearing, for them to set aside their judgment, a final judgment, to me is reprehensible. The Supreme Court was right to have given the order of cost against those cases. Why? Because all the legal practitioners in Nigeria, when you are called to bar, you go to Supreme Court to enroll as an officer of that court. If your officer misbehaves or misconducts himself, you have the right to punish that officer. So the argument that the counsels as counsels, they are not parties, they should not have been given they shall be fined. It is out of place. The Supreme Court has the powers to give cost against counsels in cases like this. Now, I do not agree with the school of thought that says Supreme Court judgment is final and that the sanctity of that finality should not be violated by coming before the court. There are instances. Look, presently, some of us are confronted with situations whereby you have a case before the Supreme Court. You are not aware of what is going on. Only for us to go there after 3 years. You discover that they said the appeal file is missing. And a temporary file is created. And that temporary file is taken before the justices in the chambers. And orders are given. You discover that some of those orders given will be given on the error that the other party has not filed a process. I am telling you this now. It's happening there. Now, if somebody has filed, if a respondent in the Supreme Court has filed his final brief, and the original file, the appeal file is missing, whether it's lost or it's stolen, and a temporary file is created, and that file only contains the appeal brief of the appellant, and it's taken before the justices in chambers, they could give another that this appeal should be heard on the appellant's brief. If a judgment is given on that premises, the respondent who has complied with the procedure of the rules could come back before that court and say, look, I have complied with the rules of this court, I have my brief before this court, and you have given a judgment on the mistaken belief that I didn't file anything. Now the issue of a file is missing, a file is not missing. If a respondent is on his custody of that file, he could converse that, look, I don't know, a mysterious circumstance like this should be investigated.
You're stating basis for a review.
A basis, that is a basis.
Okay.
Now, it is not about sessional decision is misinterpreted, fair hearing is violated. No. The rules of court is that on a particular, once record of appeal is served, the appellant will file his own brief within a period of time, the respondent will file his own brief within a period of time, the appeal could be right for hearing if both parties have complied. And I saw for just glad that there is a file before the justices, and what is there is just the process of the appellant.
Right.
And the process of the respondent is not there. The respondent will come before that court to say, look, this judgment cannot stand.
All right.
Now, it is different from you coming before the court in a judgment that has been delivered to say that, no, if you have seen this evidence, you will not have given this judgment. If you have looked at this law, that is an appeal against the judgment of that Supreme Court in the Supreme Court, and that is what I think is disagreeable.
All right.
We can't.
I have to hold you on that, Barrister Tewukun. Look at has it ever happened? Yes, the question is, has it ever happened in the history of Nigeria, in the history of the Supreme Court, to reverse itself? Barrister Kolawole.
When you look at our jurisprudence, just like Barrister Ben said, most times what usually happens is that if there are developments in law to such an extent that if they follow those principles and what have you, they might say, look, we don't want to do this part again. We'll be in fear of all these developments and all that. These are the principles of law that we now want to abide with. So the Supreme Court is a place where ordinarily they hardly will want to set aside their own judgment based on the kind of so-called briefs that both Afe Babalola and then Chief Olaolani Pekunle file. It is very, very unusual procedure. Just like he said, if, for example, Chief Afe Babalola and then Chief Olaolani Pekunle approached the court and said, look, we now have new set of evidence or new set of facts and all that, that were not available to us as at the time a decision or a ruling or this judgment was given in this particular case and all that. And you make such available to the Supreme Court and all that. Maybe the Supreme Court might be a little bit disposed towards rehearing the whole thing and then maybe, just maybe, setting aside its own judgment. But on the nebulous argument, very wide, open-ended, fair hearing could mean so many things to different people and all that. Are the people saying that as at the time they were at the Legislative Petition Tribunal, the gate of, were they shot, was the gate of proving their case shot against them when they appeared before the Legislative Petition Tribunal? And then when they also went to the Court of Appeal and all that, are they saying that the Court of Appeal didn't give them the opportunity to really canvass whatever argument that they wanted to canvass at that period of time and all that? The answer is no. But again, I want us to be very, very careful, especially in the light of what my comrade has said. The Supreme Court today is overwhelmed with a lot of work, such that certain cases that are filed today in the next 10 years is not likely to be heard at the Supreme Court. And then the Supreme Court seems not to be heeding the dictum of Okuta, of blessed memory. You say, look, the Supreme Court is not infallible. It's only infallible to the extent that it is the final authority. And if that is the case, the kind of arrogant posturing that you see in the ruling that was delivered in this review ought not to have been the case in the way the Supreme Court has handled it. In fact, I was expecting, because of the novel nature of what happened at the Supreme Court, the Supreme Court would have even called on amicus curiae, professor from the university, and said, look, come and address us on this, on the propriety of all the pleading that these people have put before us. And then our jurisprudence would have been far enriched. You may be shocked. You may be shocked. It may not be happening here, but there may be some other jurisdiction that could be of persuasive authority that some of these people in the academia may be able to put before the Supreme Court, which would have broadened our jurisdiction, and then maybe sway the Supreme Court to really be a little bit more disposed to what these people have brought. The other issue is this. Look at the trend we are seeing. Most of the cases, or most of the people that are calling for review, are mostly political cases. Sure. That speaks volume. They mostly don't happen in most of these criminal cases. Yeah. They don't happen in some of these other ordinary civil cases and all that. It is because the politicians know the people in the Supreme Court. And we may, on the points of law, be canvassing Section 285, Section 37, and all of you. The undercurrents of some of these things we don't know. And if people are abusing the processes in the Supreme Court and not, in a way you could say that the Supreme Court invited it. Why did I say they invited it? It started in a way since from the Rotimi Amechi case in my humble opinion. Here was a man in my humble opinion who said that Miu didn't contest election, and the Supreme Court said, oh, we want to teach the politician a lesson. And you ask Rotimi Amechi to become governor. So when people see some of those things and know that they are encouraged to try their luck, ordinarily where they should not try it.
All right.
Furthermore, in some other jurisdiction, let's be very careful.
Okay.
Look at a jurisdiction like the US, for example. We have had certain instances in which people have been convicted and have spent as much as 20 years in prison. But due to the invention of DNA tests and some other scientific innovations, lawyers will stumble on some of these things and say, look, DNA test has been conducted and then it shows that, look, it is this Northman that actually committed this crime. If, for example, we have that kind of an opportunity, or if that is the kind of cases that the people are taking, is the Supreme Court say it's not going to reverse itself on that matter. So that is why, because invention, I mean, in law too, you want to try, you want to try the law. Because if you don't try the law, you don't expose, you don't expand jurisprudence. And we are seeing instances in which people have, look at the case when Chief Olajuwon handled the Ladoja impeachment. Okay. Look at also when Ogunbete handled the impeachment of the deputy governor of Ondo State and all that. Under the Nigerian Constitution, do you know you cannot challenge all these impeachment processes? But Chief Olajuwon came up with an innovation, with an innovative approach in law, and we say, look, fair hearing. This man didn't get fair hearing. And based on that, Ogunbete has also gone to court and said, look, and all that.
All right, very
so we require to be a little bit more flexible in some of the way. And then I also want to say that if the Supreme Court is being abused the way we are seeing it, the Supreme Court seems, in my humble opinion, to be inviting it because they indulge the politicians a lot.
All right, Barrister Benjamin, now March 2 has been set for the review of the Imo and Zamfara judgment as well. Now, the PDP in its reaction is saying its quest for the review of the Supreme Court verdict on Imo State is not to test the finality of the apex court, but just to really assist the court to affirm its infallibility by correcting the inherent mistakes in the judgment which came as a result of the misleading presentation to it allegedly by the APC. What do you make of it? Do you see anything different from what we have from Bayelsa State in March 2 verdicts by the Supreme Court on Imo and Zamfara State?
Well, I don't think it would be right for me to sit down here and tell you, number one, that the judgment in Imo State gubernatorial election is going to come out different.
But would it be a cue? Should PDP take a cue from the Bayelsa State?
But of course, yes, they should take a cue, because if you look at what had happened during the Bayelsa rehearing application compared to what is going to happen in Imo State, because if you look at it carefully, before the application, you see, and this is very dangerous. What is happening is very dangerous. It's dangerous in the sense that politicians are dragging our justices or the Supreme Court into politics. And that is dangerous. That is one. Two, prior to when the application for review of the judgment in Bayelsa was made, of course, we already know that Imo State was already brewing. It was on ground. There were agitations in the southeast, even up to the point, I think it was after the Bayelsa that some persons went to the learned justice house to protest. You understand? Yeah. So this is a very dangerous development. Now, to come back to what you are saying, all of this thing happens at the inception of this government. How this government has gone far to wreak so much havoc on the Nigerian judiciary. And I think because whatever you sow is what you will reap. When you have given the public the impression that the judiciary is corrupt, that there's nothing good in the judiciary, I mean, what they see this government has sown is what Nigerians are beginning to gradually reap. Because the government started by arresting judges, charging them to court, whether real or not, whatever happens at the end of the day, you know. Now, people now are beginning to believe that any judgment given by the Supreme Court might, after all, not be right at the end of the day. Now, come for example now, like Barrister Kola Wale said, some of the judges or the Supreme Court has also dragged itself into some of these issues. Now, before the election, the 2020, the recent election, presidential election, justices of the Supreme Court were invited to Aso Rock. What were they doing there? Why did they have to go to Aso Rock? If the Mr. President has to see justice of the Supreme Court, couldn't there have been a public place where they could have met? So that gives room for a lot of suspicion, a lot of speculation, and all of that. So these are part of the things we are beginning to unfold. Now, I am sure by now, the camp of the PDP, I think PDP in Imo State, are jittery. They should be jittery because now they don't know, or they wouldn't know what will be the outcome at the end of when the application is had. But I wouldn't be able to tell you now that this is how the application is going to turn out. Whether it's going to be like Bayelsa State's election, I wouldn't know.
Very well.
Yes.
All right. Now, David Lyon of Bayelsa State said the Supreme Court ruling on the exercise may be seen as judgment without justice, although he has accepted his fate. Now, Barrister Temoku, what do you think this particular finality by the Supreme Court, what does it say? What does it mean for our judicial arm of government, our democracy, and electoral process?
Yes, let me start by saying that the question that I was posed to my learned friend about the scenario in Imo State and that of Bayelsa, I think one should also be careful not to discourage courage at the bar. People that have developed our jurisprudence at this level, they were the courageous ones in the past. People like Ganifa, they filed a lot of cases. Most of these cases, they might not win. But if it is just one or two that was able to bring up new breakthroughs, jurisprudentially, some of these principles are dirty today. To me, we owe it a duty not to make pronouncements that could prejudice the positions that the court might take on these cases. But I still encourage the councils. I still encourage the councils that are in Imo State case and Zamfara. I'll be very honest with you. Coincidentally, I was in court the last time. The matter came up when they adjourned for this month. Second, Baba Clark, who appeared for Zamfara, was there, at late 80s. Baba was visibly shaking in court. He was shaking, and when the Supreme Court justice asked him to sit down, he said he started arguing the case. He said I will stand as long as I can. He said because of justice, because of judgment is a non-iter ab initio. My consequence may have to stand up and say he's already arguing the case. Now, If you now look at what happened in Bayelsa case and say, no, Baba should not go back to, that they should withdraw. Why? No, they should go back. They should go back. I'll be very honest with you. That case of Imo State, we can't pronounce on it here. But in the situation whereby somebody was declared to have been the winner and some of the votes that the person came to declare actually surpassed the accredited votes in particular polling units. And the law is there that without accreditation there cannot be valid votes. So this situation no different from the case of Baba Abalola and Chief Odewale Anigbeku. They are different. They must still go back to Supreme Court. Let Supreme Court still pronounce on their own cases within the peculiar circumstances of their case. So because the finality we are talking about, we must continue to appreciate that finality. Without that finality, you can be doing your cases from magistrate court to any level, and once you get to Supreme Court, we will say, no, that is the end. Yes, we must agree with that. Is what we must celebrate. But that finality, the celebration of the sanctity of that finality is not what makes it to be final. The justice of the case, the judgments that will be coming from Supreme Court should be unimpeachable. Supreme Court must be able to defend that finality. It is not because we have said it that okay, we are final because we are infallible. No, let the Supreme Court stand on its toes to defend that finality by coming out with judgment that people will look at 10 times and will say no, there is no loophole here. If we begin to come out with judgments that people will look at and say this is injustice, we should have the courage not to live with that injustice. We should have the courage to say, look, down with this injustice. We'll go back to Supreme Court. God himself had reversed decisions several occasions in the Bible. We were taught. God sent Prophet Isaiah to King Ezekiah that he was going to die when he was sick. But when he looked unto God, he reminded the God the thing I did. He said, God, I have served you. Look at what I have done. Look at what I have done. God said, I will add 15 years to your years. The same thing happened to Jonah when he was sent to people of Nineveh that was going to destroy them. So now, what is the finality we are talking about? Is it that even when it is injustice, it is final? No, let us live with this final injustice. We cannot live with any final injustice. If it is injustice, the Supreme Court will be able to look at those decisions. And if it is a situation that is deserving of a review, it should be reviewed. It should be set aside outrightly. Because when we begin to live with it, people that have faith in the supremacy of the Supreme Court and that have taken the judiciary resolution of their disputes, they will be encouraged to look the other way. People will go for, look at people have gone to the house of a justice of the Supreme Court to protest, to barricade the road, to say, look, nobody is going anywhere. It's because of what they perceived. We should be careful to ensure that it is not the finality we are celebrating. The sanctity is in the correctness of that finality, not the finality itself.
All right. What cue can politicians take from this particular judgment? That of March 2 is in the offing. From then on, I know a whole lot of lessons will be learned. But from the Bayelsa case, to be precise, what do you think politicians must have learned now?
For me, Nigerian politicians are very incorrigible people. I doubt it whether they will learn any lesson from what has happened from the Bayelsa, the ruling from the Supreme Court with respect to the Bayelsa case and all that. And this is because most of them thrive on impunity. They thrive on impunity. They also believe that there is no institution that they cannot compromise. And you may not contest that with them because they have so much resources at their disposal, which they don't account for, and upon which nobody ever hold them responsible for anything. So if a man has that kind of resources, and they have not only, they've even gone beyond that now. Most of the leading politicians now have private armies who are well armed, who are well paid, who they use to terrorize their political opponent and use to ensure that they win elections at all costs. So if you have that kind of an elite who don't believe in the system, or who only believe in the ruling or judgment of the court when it favors them, you hardly would expect them to learn any lesson. The onus is on the Supreme Court and most of our judges, most of our courts in order to say, look, you have desecrated the legislator, you bastardized the executive, the courts, the judiciary is the only habitat that we have left that separates these two, and then upon which the ordinary man on the street will want to put his hope that, look, when something happens to me, I can be sure that at least I will get justice at the end of the day. We will not allow you to desecrate that a sacred institution. If the justice system, if we who apply our trade, both as lawyers and those on the bench and all that, don't make this kind of resolutions and what have you and all that, the politicians will continue to try their luck. They will continue to go in back in there and continue to desecrate most of these institutions. So the onus is on us to really make sure that we put an end. It's not all about money. Because when you bastardize, when look at the level of insecurity in society now, no matter what monies you have, no matter what electric barbed wires you have in your houses and all that, they still come for you. They have a way of coming for you.
All right.
And all that. And then more importantly, in addition to what my comrade has said, Tomokun, look, Lord Dennis said something. He said, look, justice is not too much outside the perception of the ordinary man on the street. That if an ordinary man who sees through an entire proceeding in a matter, an entire proceeding in the court of law, comes out with the impression and says, look, I think justice has been done in this case, then that is justice. It is not about what the lawyers who appeared in the matters alone said. It is not about even just the ordinary the cold letters of the law, which the judges interpreted. The common man must also have the confidence, must have the faith, must have the trust that our court system are doing the right thing.
All right.
If we don't ensure that they do the right thing and all that, you continue to have the kind of demonstration that we have against the justices and judges.
Thank you very much, Olawale. All right, and before we move on from this particular topic, one thing that struck many Nigerians when this particular judgment was delivered on the 13th of February was the fact that it was barely 24 hours to David Lyons swearing in, and Barrister Kolawole did talk about the cases before the Supreme Court, overwhelming workload. Now, do you think the judiciary has a lot to do to, ensure that justice is dispensed timely? We can't begin to describe the emotional trauma David Lyons must have gone through when that judgment came. We saw pictures of him rehearsing, for his swearing in. Mr. Benjamin.
Of course, that's the unfortunate part of what that incident that happened. Well, I think that the judiciary is already doing a lot, in terms of dispensation of justice, quick dispensation of justice as regards electoral cases and all of that. Probably, I think they should do more amendments in the Electoral Act so as to, facilitate faster dispensation of justice as regard election petition cases. Well, of course, if you look at it from both ways, because when they went to court, both parties went to court. They filed all manner of petition, took evidences and all of it. It all depends on the volume of witnesses that were called, volumes of testimonies and documents that were tendered. Then at the end of the day, the judges at the tribunal have to sit down, evaluate the evidence, and make their decision. Now, it went all the way to the Supreme Court, so that's a lot of time, except if they still have to carry out more amendments in the Electoral Act to expand whatever the time.
All right, Barrister Tomoko, one question I hear this people discussing it. Would it have made any difference if the judgment came after David Lyons and Degi Eremium were inaugurated? Would it have made any difference?
Yes, that is just a matter of sentiment. It's just a matter of sentiment.
That's a lot of time, yeah.
What my brother said, the issue of timing is also important. But to me, I still feel, because to be very honest, the Supreme Court in Nigeria of today is overwhelmed. It's overwhelmed. Cases of 2011, some of these cases have not gone to chambers in Supreme Court. So now, how long do we, because now, okay, if not for the fact that these are electoral cases, and in the course of those electoral cases, so we still have cases, the day the Imo State and Zamfara came up, it was about 6 panels that sat in the Supreme Court. 6 panels, the first one had about 15 cases. So it is not as if once it is electoral matter, that is the only matter they will hear. No. They see all other cases. How long do we continue with this kind of situation? There must be, when they were interviewing the candidates for the office of the Attorney General, Professor Kayamo mentioned one thing. People may think maybe it was playing to gallery, but I think it's also very, very important. The fact that you have a Supreme Court in Abuja that is sitting on all these cases, I think that a time must come. It must be unbundled. To be very honest with you, it's not a matter of if you have Supreme Court in Akure or Lagos. Maybe Tinubu can compromise the one in Lagos, Aketi can compromise the one. No, we should look away from the Supreme Court cannot continue to be this one Supreme Court in Abuja that is hearing all these cases.
200 million people.
It cannot. It is not possible. And look at some of these errors that occur. Somebody in a faraway Bayelsa or even Maduguri who has an appeal in Supreme Court. You don't expect that person to be coming to Supreme Court every day to know what is going on about his case. Before you know it, the other party can now play mischief and now maybe they say a file is missing before you say they will just divide judgment. Why would that person not come back? Those imperfections are made to happen because of this over-centralized system that is happening in the executive. The same thing is happening in the judiciary. So if the judgment had been delivered the second day after inauguration, it would have been worse because the rehearsal is just a rehearsal. It's just like a mock. It's not an exam. But now he rehearsed. He was not sworn in. It would have been worse if he had been sworn in and the woman had gone to the village killing cows for everybody as the first lady. The judgment now came. So it's just a matter of sentiment. Supreme Court has delivered its ruling. They have delivered their ruling. And that is for now.
All right, so you're watching Democracy and the Rule of Law, and what we just wrapped up on is the final judgment of the Supreme Court on the Bayelsa election.